Old Path Box. When is that one coming back? When is those coming back? Okay. That's correct. We was good with that because that's why the Old Path.
And Mr. Jones, I think his email, so.
We'll talk. I'm not denying it. I'm not denying the safety. It says specific with a use.
Primary use is in parking lot.
It's a difference, man.
No, it's not. C1 lists as a specific.
Look at the difference between the one and the other. Look at the difference. It's a difference. It's different. If this is associated with
Or it's a
business, it's a storage facility for what use. See, that's what I'm trying to say. Well,
She made a tea earlier today, so we're using it.
it's still use. You just can't.
Oh, maybe it's.
We don't know.
we don't want to know what
You say, well, I could do the same the day of the billboard when we get back. I could do all that. Yeah, you don't understand the price, right?
use it.
I understand that. But let's talk history. Let's talk about it. Well, I'm reluctant to sign it. So,
I mean, I'll appreciate that you agree on what we can, but
let's have all together.
I'll come. Well, I don't know if you agree. We'll agree after.
But they know.
You see,
Yes,
you see, the session is just out of get out of jail.
just in case. But they know.
Well, you can.
Yeah.
But
Yeah.
see, it says a use. There's a difference between like parking lots that we want to do. That we have yeah, so talk to the client. Because see, one thing okay, so you want it to be like a storage yard.
That run and have never.
So, is he going? What is going to be prepared? They're just going to be broken. See, it's a lesson. When you stretch it out. Well, what are you going to do with the cars? Just keep it in. See what I'm saying? The definition of savage is very, very broad. But look at the definition of savage yard. It's very, very broad. We went down this road in Catalina. It's very, very broad.
That's what I said last night.
You're still not having completed everything that you need to do. I'm not going to argue with her. If code enforcement comes up again, that's her. And I think she had engineering. But yeah, that's I gotta have a little bit more because there's all that time. That's a lot for storage. But it this thing, but it's contingent upon some things on whatever. So, but it just you got to see the structures accessory. Ideally, it's accessory. Parking lot is different. Parking lot is a community. I can't work that. We want to send it over y'all. Parking lot. It's definitely parking lot. It's still Smith, you talking? Go by the words. It's typically how it's done. I'm not working. I understand. Yes. I'm not concerned about that. No. I just that should be.
It's kangaroos back there.
No, he cannot. Because he can't. He got the fish to go on the site planning process. I know because I talked to him. And we told him this before. He went on there. He got to circumvent the process. So that's my concern. Well, he already started.
All right. Good morning, everybody. 6 of us. All right. This meeting of the Escambia County Planning Board for January 6, 2026 is hereby called to order. With 6 members present, we do have a quorum. Just a reminder to turn off your cell phones or put them on silent as we proceed with the meeting. If you could, please stand for the Pledge of Allegiance. right. Did we have proof of publication?
Yes, sir.
Publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, okay, motion carries. The meeting minutes from the previous meeting dated December 2nd have been provided to the board members. Are there any additions, deletions, or corrections? And if not, I'll entertain a motion.
So moved.
Second.
The motion is second. All those in favor, please signify by raising your right hand. All right, rezoning hearing package for today's meeting with findings of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into evidence. Do we have a motion?
Motion to accept.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. All right, motion carries. Will the court reporter please swear in members of the staff?
Or affirm testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth.
All right, and the planning board has previously qualified staff to offer expert testimony in the area of land use and planning. If anyone has any questions regarding their qualifications and ability to offer expert testimony, please speak now. Seeing none. All right, at this hearing, the planning board is acting under its authority to hear and make recommendations to the BCC.
To expedite this meeting, do you want to make
Yeah.
a motion to waive the reading today?
We've got a motion to waive the reading. We've got a second. Any discussion? All those in favor, please signify by raising your right hand. Okay, all those opposed. All right. So at the beginning of each case, as long as there's no objections from the applicant, we'll allow staff to briefly present the location and zoning maps and photo of the property for the case. Next, we'll hear from the applicant and any witnesses they may wish to bring. And then we'll hear from staff and any witnesses they may wish to bring. And finally, we'll hear from members of the public who have filled out a speaker request form. There's one case to be heard today, and that's rezoning application for consideration, case Z 2025-13. Request rezoning of the 600 block of Cessna Road from MDR medium density residential district, 10 dwelling units per acre, to HDR high density residential district, 18 dwelling units per acre, requested by Meredith Bush, the agent for Arena Land LLC, the owner. Members of the board, have there been any ex parte communication between you, the applicant, or the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
I have visited the site and no to the rest.
No to all.
No to all?
No to all.
No to all.
No to all.
All right. Staff was notice of the hearing sent to all interested parties.
Yes, sir.
Was notice of the hearing posted on the subject property?
Yes, sir.
All right. And Meredith, do you want them to go through the photographs, or did you?
No, good morning, Meredith Bush, 314 South Bayland, Suite 108, Pensacola, Florida, 32502, here on behalf of Renaland. We received staff's findings about a week ago, a little over a week ago, I think, and last week advised staff that we'd be pulling the application and withdrawing the request. You know, this is a case that started out as a commercial ask. We looked at HDMU, we met with the community. We thought coming in with an HDR would be the most likely, or, you know, for any potential increase in uses. However, given staff's findings and the community outcry, we're withdrawing the request.
Okay. Thank you, Ms. Bush. And that was our only case that we had today for rezoning. Members of the public, I appreciate you showing up in force today. And Mr. Jones, if
Yes, sir. And again, and we do want to say now, for the record, for the community, they can make a decision to come back in if they want to. However, the same process will have to occur. Notification, they pay for everything again, but the process is still available for them. The layout of the land still will not change. I just want to make that for the record clear, that they still have their right as property owners to come back in and make another attempt if they do this, if they do desire. the process, the facts, everything will remain the same again.
All right, thank you, Mr. Jones. And so if they wanted to come back, or if any of them would like to come and rezone their property, they could as well. But everybody would get notified just as it did. Okay, great. All right. I guess there's nothing further on this, so we'll adjourn this rezoning case and go into our regular board meeting. The meeting of the Escambia County Planning Board for January 6th is hereby called to order with 6 members. We do have a quorum. Do we have proof of publication?
Yes, sir.
Chair,
Yes.
would you like to explain to the audience? Okay, it looks like they got it.
Oh, okay.
Okay.
Yeah, I got my notes to say. Thank you. Thank you.
Unless you just want to hang out.
Yeah. Thank y'all for coming.
Drew, you're the lone one back there.
He's trying to hide.
Actually, that's a great picture right there. I don't think we've ever had one kind of just flat out like that.
Yeah. Yeah, thanks for saying that.
Thank you for the brief one today.
All right. So we've got our regular planning board meeting with 6 members present. We do have a quorum. Do we have proof of publication?
Yes, sir.
Does the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Motion.
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries. Planning board meeting minutes for November 4th have been provided to the board. I'll entertain a motion to accept the planning board meeting minutes into evidence. Do we have a motion?
Motion.
Second.
There's a motion and a second. All those in favor, please signify by raising your right hand. Motion carries. Planning board hearing package for January 6th has been provided to the board members. I'll entertain a motion to accept the planning board hearing package and legal advertisement into evidence. Do we have a motion?
So moved.
Second.
All right, motion is second. All those in favor, please signify by raising your right hand. All right, motion carries. A public hearing concerning the review of an ordinance amending Chapter 4, Article 7, Supplemental Use Regulations to create Section 4-7.18 relating to certified recovery, residence, and reasonable accommodation procedures. Staff, if you would proceed with your presentation.
I'll actually be the one proceeding, and I'll read my spiel here on it and then answer any questions you guys have. So a state certified recovery residence is a residential dwelling that houses individuals recovering from substance abuse disorders that holds a valid certificate of compliance under Section 397-487 Florida statutes. This ordinance establishes a formal written process in the Land Development Code for how the county reviews reasonable accommodation requests submitted by these types of certified recovery residences. This is due to state legislation requiring this in Senate Bill 954, now codified 397-487 Florida statutes, and enables the county to have a formal process to follow the requirements of the Fair Housing Act and Americans with Disabilities Act, both federal law. It largely just formalizes the process for requesting a reasonable accommodation for these types of residences. Under the ordinance, an applicant submits a written request identifying the specific LDC requirement at issue and explaining why accommodation is necessary. Examples include occupancy limits, parking requirements, spacing, or similar development regulations depending on the facts of the request. Each request is evaluated on a case-by-case basis, considering whether the accommodation is reasonable and necessary to provide equal housing opportunity and whether it would impose undue financial or administrative burden on the county or result in a fundamental alteration of the county's land use framework. A written decision is issued within required timelines, I believe 14 days, with appeal rights to the Board of County Commissioners in a quasi-judicial proceeding. Any approval remains conditioned on continued state certification and compliance with the state certification requirements for certified recovery residences. It doesn't obviously guarantee approval of any request. It just provides a clear, now required process for considering limited flexibility in code requirements consistent with that state and federal law.
All right, thank you. Board members, are there any questions for staff? All right. Oh, yep. Nope. Okay. Seeing as we do not have any public comment, If there's no questions, I will entertain a motion on this ordinance amendment.
Motion to approve.
Motion to approve. Is there a second?
Second.
Second. Any discussion on the motion? All those in favor, please signify by raising your right hand. All those opposed, motion carries. Staff, do you have anything for us? Other than we'll be back here Tuesday, February 3rd.
Right now, I do have 3 cases for next month.
Okay. Very good. All right. If there's nothing else, we stand adjourned.
That's a record, at the time I've been here, that's a record. You're still here, I've been here more.
I could even cut mine down if I wanted to. Yeah.
Peace and quiet, right?
You didn't get to say a word.
That's the best kind, right?
Yeah.
They can't not.
I get that. This point, I mean, we ain't got to beat down the door for certified recovery, reasonable accommodation. But I think we'll work.
Nobody's even asking us.
Yeah, really.
Work up a form.
See ya.
Thank you.